Absolutely. Good morning, Mr. Chair. Thank you, committee members, Representative Schofield. My name is Laura Tamez, and I am here representing the Texas Trial Lawyers Association as well as myself individually. And I would like to begin, we are opposed to the bill, and I'd like to begin with talking a little bit about attorney-client privilege, and that Texas jurisprudence prides itself on relatively open discovery. So attorney-client privilege is just that, a privilege. And that privilege is set out by the Supreme Court in the XL case. Basically protects the communications when an attorney is rendering legal services and advice to a client. Within the XL court case, the Supreme Court said that's not the case here. There is not that special relationship where, let's say I go to the doctor, I have a physician-patient privilege between my doctor and myself. If my Aunt Ruth goes with me and she pays for my medical, she may be invested in that because she paid for my medical treatment, but she wouldn't have a physician-patient relationship with that doctor because she's not the patient. So that's part of what the Supreme Court set out in the XL case. And why is that important? Let me just say that the attorney-client privilege does not protect communications between, let's say, an attorney and a witness. Many times an employer is a witness in a comp case or in a third-party case, which is what I'm here to visit with you about. I don't necessarily practice or don't practice workers' comp at the administrative level. I have for over 20 years represented Texas workers in third-party cases. And so this bill does not exclude litigation in third-party cases. And the attorney-client privilege or the hiding of evidence potentially could bleed into a third-party case. And this is why it's important. Some of the unintended consequences, and I have 5 points. The unintended consequences, let's start with this scenario. There's a general contractor, there's a subcontractor, and there's a subcontractor. And these are real cases. Many times the subcontractor is the employer. That is comp barred in third-party liability cases. So the underlying workers' comp case is very important to third-party liability cases to all parties, whether it's the injured Texan or it's the general contractor or the subcontractor. Everybody wants to see that workers' comp file because many times the employer performs an investigation. And that comp file is laden with evidence because they're the boots on the ground when an incident occurs. So that file, many times the general contractor will order it or the injured party will order it. If there is an attorney-client privilege, then there could be some hidden evidence or secret evidence. And here's point number 1 as to why that's important to all parties, whether you're on the defense or on the plaintiff side. Number 1, many times the general contractor or the subcontractors are seeking an indemnity from the employer, those subs. And it would lend itself to shifting responsibility in this manner. So within the third-party cases, you've got indemnity issues, right, between the GC and an employer. You also have some times where the employer, if the worker is not killed, right, the employer is comp barred. The employer cannot be sued because they have comp. Therefore, they can be named as a responsible third party. But if they're unable to testify as to the facts and the evidence of incidents or documents or communications, then that secret evidence hurts everyone. And there could be a shifting of responsibility if the employer says, I can't talk about that because I've already talked to the lawyer about it, then the injured worker may have no choice but to look at the general contractor or the subcontractor because the employer can't talk about their own liability, perhaps. The other issue is this, in the gross negligence context, when the shifting of responsibility happens, if there is a worker who's killed and the employer is sued, but they're able to hide facts because they've got this attorney-client privilege, but they were responsible in some part, again, because they can't come out with the true responsible party, the general contractor, the subcontractors may be the only ones who the evidence will be against. It just depends. So that's where the shifting of responsibility comes out. Point number 2 is what I call the cake and eat it too unintended consequence. Let's say that there is a third-party case, and in the tripartite insurance, the layers of insurance as they work. So an employer may have workers' comp insurance, they may have the CGL policy, and then there's an EL policy that covers the gross negligence claims. The workers' compensation carrier or policy is going to have its handout at the end of the day if the injured worker collects from the general contractor and the subcontractor who are non-employers. The employer's workers' comp carrier may have their handout and say, we have a subrogation. So whatever the injured worker collects, that comp carrier is going to say, we're entitled to a portion of that money back. But we're not going to tell you any of the facts of the case. So it's kind of a cake and eat it too, in the sense that the comp carrier gets its money back, but the employer witness or responsible third party is unable to share some of the facts. And at the end of the day, it enables some collusion in that as an unintended consequence. Point number 3. This could increase litigation costs at the third party level in this manner. So if the employer is called to testify, or a coworker, whomever it is, that was a witness or on the ground at the time of the incident, and they say, I can't answer that because my attorney has advised me that there's a privilege here, then it's going to increase our time to go to the courts. We have to file motions to compel. There will be protective orders filed by the employer. The court will have to review all of these documents or communications in camera, which would increase litigation costs not only for the injured worker, but all the other defendants in the third-party case. So attorney-client privileges impact judicial economy because they have to determine if it's truly a privilege. Is it truly a lawyer rendering legal advice to a client? Here, this would be automatic and say yes, but why would they be entitled to the special privilege? Point number 4, socialized damages or shifting costs. In the event that there are hidden facts or secret evidence that happens because of this attorney-client privilege, the responsible party cannot be determined, and the injured worker is unable to be compensated. And there may be no third-party liability for the medical portion of it. Then that cost is transferred on to the taxpayer. They have to seek disability if they can no longer work. And that is, again, an unintended consequence of hiding evidence. We want to know who the responsible party is. So and finally, the slippery slope is when we talk about if this is just narrowly tailored to those employers who have a deductible or whatever the amount is, $5,000, $1 million. In 2 sessions, those employers who don't have to pay a deductible, but they say, hey, my premiums go up every year when somebody files a comp claim, will come back and say, how come we are not entitled to the privilege? Basically everyone would want this special privilege, and that's where the slippery slope takes over. So those are my points. I'm happy to answer any questions you may have.
Any questions? Representative Collins.
Ms. Tamez, thank you so much. This was a really good layout, and it helps me understand. You brought up some points that I didn't even think about responsible third-party issues, and then also with the subcontractor and the general contractor, because you're right, if I was going to have a claim, I would go after all of them. And if they're the one that's the sub that you gave the incident, the example of, they're going to say, I can't discuss this with the GC and the sub, and that's going to cause more litigation where you're going to have to do more work to try to get the information from them. So that's a good point. I appreciate that. And then also, so my question is about when you were talking about the shifting the cake and eat it too.
Yes.
Then that's a concern, because then you're saying that they can go back and get the money from the GC if they had to pay something out?
Yes, Representative Collier. So the cake and eat it too part is when a employee or a worker sues a third party, many times and they have received benefits from the workers' comp carrier. That workers' comp carrier can seek subrogation rights from that third party. So the general contractor, the sub, whomever pays, let's say there's a settlement or a judgment, the workers' comp carrier is going to ask for their money back. The cake in it too is how can they cloak some of the evidence with a privilege, yet, and then the employee can only go back to the GC and the sub for compensation, but then they get their money back.
Right, right.
So that's where the cake and it
They're hiding, okay.
comes in, yes.
And then also the last thing, when I think the chairman, Oliveira, talked about how being a named defendant in the case. So I think that this is one of the reasons why we have that non-adversarial portion is because that way, if you worked for a company, ABC company, and ABC company has a bunch of workers' comp claims. Well, one of the benefit of having a workers' compensation carrier, you're suing the carrier and not ABC, so it helps with public perception of the ABC company because then they're not being sued all the time because of these workers' comp claims, and it doesn't look like they have a problem within their company. So I think that's what the difference between a car wreck case and when you're suing Joe Smith versus State Farm, and in this case where you're suing, the insurance carrier, the actual carrier.
Correct. Yes, Representative, that is true. It's
So-
a different relationship.
Right.
The relationship that's focused upon here is an attorney-client relationship, where there's that special communication between a lawyer and a client, but the lawyer's got to be rendering legal services and advice.
Right.
And that's what the bill is requiring or requesting in terms of let's create this special relationship, even though they're truly not.
There is no relationship.
Correct. An attorney and a client where they're rendering legal services. That's the true nature of it.
Thank you.
Representative Workman.
Okay, so you agree with the no-fault concept of workers' comp, is that correct?
Well, I didn't testify on that portion of it,
I
Representative
know, but I'm
Workman.
just asking your opinion about the no-fault part of work comp. Do you think that's bad or good?
Well, I agree that's the law. And I agree that's the law that we've had for quite some time, yes.
So you think then an employee should be able to sue their employer even if they have workers' comp?
Well, in the event of a gross negligence, that's also the law, so that can
Okay,
happen.
but a normal,
Yes.
not gross negligence, do you believe that the employee should be able to sue the employer?
Well, it depends on the context of the claim.
Okay, so you're fine with third-party overaction lawsuits against a general contractor from an employee of a sub?
To find the responsible party, yes.
Okay, so you would be opposed to the statutory employer concept?
Well, I believe that there is a statutory employer concept at the moment when it comes to employers, but
Well,
what
it
you're
is
talking
under
about is...
an OSIP perhaps, but not in the normal situation, there's not. So you're opposed to that for a general contractor who pays for the work comp of the subcontractor?
Opposed in the sense that, in what context?
You don't want to give up the right of the employee to be able to sue someone if they don't think workers' comp took care of them.
Well, Representative Workman, again, it depends on the context and the details, but at the moment, they have the opportunity to do so, to determine the responsible party of who should pay that compensation so that that worker doesn't have to get on some kind of governmental assistance.
Okay. So but do you agree that in some cases an employee sues a general contractor and the general contractor had nothing to do with the accident? Do you think that happens?
Not that I've ever represented
Okay.
an employee.
All right, thank you.
Any other questions? Thank you, ma'am.
Thank you.
We have two.